Good afternoon, everyone. Great
Good
to
afternoon.
see all of you here. You're very welcome. Welcome to the NBA-SBL Business Law Weekly, Season 3, Episode 4, from the Restructuring and Insolvency Committee of the NBA-SBL. And today we would be dealing with navigating through insolvency of public enterprises and practical insights. Once again, good afternoon. My name is Okori Carlo. I'm the chairman of the Restructuring and Insolvency Committee of the Section of Business Law of the NBA, and you are all welcome. We thank the chair, who has been very supportive, and the secretariat for helping us to host this. Without much ado, I would like to hand over to my colleague, the second vice chair, Tosin Yayi, who will be moderating this session. Thank you very much.
Good afternoon, everyone, and you're welcome to the fourth episode of this season of the Weekly Business Series. So today we're going to be talking about insolvency of public enterprises. But before I go into that, hello, can you hear me?
Yes, I can hear you.
Yes, okay. Before I go into that, I'd like to introduce our speakers. Today we have two speakers, and the first person is Mr. Adetokunbo Aguru. He's a lawyer and he's the managing partner of Jaye Aguru and Co., a firm founded by his late father, who was also a lawyer. And Mr. Aguru is someone who has specialty in the areas of insolvency, liquidation, and privatization of enterprises. And he also does corporate transactions, and he also does a bit of mediation. In fact, he's on the governing council of the Citizens Mediation Center, amongst other things that he does. Welcome, Mr. Aguru.
Thank you very much. Thanks for the warm welcome.
Our second speaker for today is Mr. Folonsho, Mr. Albert Folonsho. He's a fellow of the Institute of Chartered Accountants of Nigeria. He's also a fellow of the Chartered Institute of Taxation of Nigeria. He's a partner and managing consultant at Pedable Consultants. And he does a lot of tax advisory and financial advisory as well. So welcome, Mr. Folonsho. So, Mr. Aguru,
yes,
we're just going to dive right into it. So today we're talking the liquidation of public enterprises. You know what public enterprises are? We have many examples of them around us, the NTAs, FRCNs, and the NITELs of this world. But in some instances, we've actually seen some of them go into liquidation. Now, today we want you to tell us, to give us practical insight, and that's what we hope to glean from today's conversation. Practical insights, the behind the scenes, the things we don't see in the law books or in the statutes, things that go on behind the scenes, things that, in fact, from the beginning of when the decision is taken for those companies to go, for those enterprises to go into liquidation to the end. So we're hoping that at the end of today, the members of the audience will have a better understanding, practical understanding of what insolvency of public enterprises is all about. So, of course, for many of these companies, we know that as with liquidation, it arises from a company maybe no longer being viable or unable to pay its debt. And at some point, that decision has to be made. Now, for public enterprises, can you just share with us how we get to that point?
Thank you very much, Tosin, and thanks everybody for having me. The decision to wind up a public enterprise or to privatize this is actually statutory. If you look at the Public Enterprises and Privatization and Commercialization Act in Schedule 1, there's a whole list there of different enterprises. I think there are about 15 or in fact about 30 or 40 of them, which the government in itself, the FGN, has decided that those companies ought to be wound up or liquidated for various reasons, mostly because basically, first and foremost, to stop the bleeding. When I say bleeding, to stop pumping good money into bad. Basically, whereby that enterprise in itself is no longer viable. There's no point in pouring money into it. So government came up with a decision and said, listen, the best thing to do is to privatize these companies. So that's the starting point, is in the law, and the list of companies are already there. And the body in charge of that particular public enterprise process is the National Council on Privatization, and its implementation arm is called the Bureau of Public Enterprises. So those are the people who set the ball running in regards to privatization of public enterprises.
Thank you very much, Mr. Falon. So, sorry, Mr. Aguro. Now, with some public enterprises, and I know that there's one that you're going to speak to in the course of this conversation. I know that you were also a part and parcel of that process. And I'll pick on NITEL. When NITEL was being liquidated, we're told that it was going to go through what they call a guided liquidation. Now, that whole guided liquidation is not really something you will see in the books. So can you please walk us through what that is all about?
Okay, thank you very much. I came across the language guided liquidation from the liquidation done by the BP of NAFCON. I think that's, if I'm right, that was 2001. That's the first guided liquidation transaction that I came across. And simply what it means is liquidating a company through the guidance of governments. And that government arm, as I said, is the Bureau of Public Enterprise, who is the secretariat and implementing body of NCP. So they came up with that phrase, guided. And what they mean by guided is that although it's a court-appointed transaction, but every step taken has to also get the nod or approval of the Bureau of Public Enterprise, because they are really the appointing body. It's their transaction. And for them to be in the forefront and part and parcel of it, they encompass the transaction from onset till dissolution and discharge of the liquidator. So what we mean by guided is the BP, which is an organ of government, is part and parcel of the transaction. And that's what you don't see in non-public enterprises. That's the main difference. With other public with other liquidation, is simply the courts and the liquidator and the company, and those people involved in the company. But with public enterprise liquidation, it involves the Bureau of Public Enterprise. So that's the key difference.
Okay, thank you. And this leads me to my other question. So the other question I want to ask is that we know that for regular companies and not public enterprises, it can either the winding up of those companies can either be done by compulsory winding up, or members voluntary winding up, or creditors winding up. Now, this guided liquidation, so to speak, how does it differ in terms with winding up as we know it, of regular public or private companies?
Yes, I think I touched on that in my last answer. The main reason for guided liquidation is to help governments with additional cash flow. Not so much from the sale of the assets, but more from stopping them from pumping money into an enterprise that is not making any money. So we all know the phrase that government has no business in business. So I think it was based on that principle that they said, we're going to hands off most of these enterprises, privatize them into private hands, and in some occasions, keep a little bit of shares, and in some occasions, let it be holistically sold to a third party. So basically, there are different modes of winding up, but in particular, one that suits government the best is this compulsory winding up by court. What that does, in effect, is that it removes the liability of that enterprise from the person buying it. We've had situations whereby you purchase a company, buy sale shares, and the person who bought it has the burden of dealing with all the liabilities. But what this does for the investor is that it hands over a clean slate, only the assets and just basically the assets on its own with no liabilities. So that's more attractive and easier to sell than pure privatization on its own. So that's the main key. So the issue of voluntary winding up, those are really for where there is no issue between the companies and all of them, the members have agreed that we want to wind up. But in particular with this one, is usually where the company in itself is does not have the ability to stay by himself, stand by his own, or pay his debts. Thereby, a liquidator will be appointed to assist it towards its dissolution.
Thank you very much, Mr. Agoro. So I'll pause with you for a moment and I'll go to Mr. Folonso. Thanks for joining us, Mr. Folonso.
Thank you, Justin.
I mean, like I told our listeners, you're an accountant. So you're not, you've been involved in several of these liquidation exercises. Now, from your perspective, and we know that the law and accounting go hand in hand when it comes to insolvency. You have to do what the law says, what the statutes say. At the same time, you need to keep an eye on those numbers. So from your perspective, can you please touch on the issue of valuation? How important is valuation when it comes to the liquidation or doing a winding up exercise of a public enterprise? How important is that?
Okay, thank you very much for having me today on this call and speaking to you on insolvency of public enterprises. The difference is really very wide when it comes to what Mr. Agoro has called guided liquidation. I've had that severally. And of course, when you are discussing limited liability companies or PLC, one of the key issues to consider is the valuation of the asset of the distressed entity. Okay, and of course, we know that the way the public enterprises goes is that they call for closed bids, more or less, for most of them. But of course, they also have their reserved, price, more or less, if I can call it that. And for you to come up with your own reserve price, you have to use all of those valuation methods, that are also applicable to corporate entities. And those are where the accountants are definitely required to come in most times. For distressed entities, for a company that is a going concern, the preferred valuation method is usually the discounted cash flow of future revenue that is most desired. But of course, we know that when the company becomes distressed, other methods may have to be considered. We have the enterprise valuation method, and of course, which will take into consideration the requirement of preferential interest. For public enterprises of those magnitude, with quite a number of assets in place, you also look at the fixed assets, the net asset position of those entities. And the experience is that most of the assets of those entities are usually run down. Imagine privatizing, liquidating a Kaduna refinery. I've been there for some time. And if you look at most of the assets, they are disused. They are things that are 100% mostly outdated. They are out of tune. And that is why you are seeing them going through every year a turnaround. They cannot be turned around except you do a holistic rehabilitation and turn them into more modern. So all of those methods have to be brought in. Individual interest always affect your valuation, from the creditor side and from the debtor side. You know, that is more prevalent when you are dealing with corporate entity. But for public enterprises that we are speaking to on this course, in this webinar, it is strictly how do you determine the reserve price? They throw it open to the public, and it is those who are interested. I have a couple of clients that have been taken over from those type of public enterprises, like the power companies, okay, the Gencos. A number of them were acquired through that process. The Gregu plant in Ajaokuta, and we have the Egbin Power. They were all taken over by private sector. How are the values determined? Of course, the individual that are interested carry out proper projection, valuation on these assets to be able to know what is the expected cash inflow, and then how sustainable are these assets in the foreseeable future. And then after using all of different type of methods that are applicable in valuation, sometimes, like it is done in the US, you do an average of the estimate of the valuation over a particular method that have been taken into consideration, so that it can reduce the bias that may be associated with a particular type of method, either the net asset base, the expected cash flow. Those are the major ones that, you know, are always relevant when you are considering acquiring a public enterprise of those nature. And again, you also look at the reputation. Okay, reputation have a lot to do with determining those what value a person will want to pay for such enterprises. And those are where expertise is required. And those are the basis for you to submit your competitive bid, because sometimes you see some of those bids, they are far apart in terms of what people submit. And that is why you have usually a preferred bidder who is wide apart from what others have brought into consideration. So there is always a need to revalue those public assets before determining your interest in those public enterprises. Now I'm speaking from the bidder's point of view.
Yes. So the accountant, so what do the accountants then do in that process? Apart from doing the valuation, do accountants also advise the enterprise that is about to be taken over?
Of course.
Do both sides engage accountants, apart from the bidder? Okay.
No, the last question has to do with valuation. A whole lot of things are involved before you liquidate, or not liquidate now, before an interest in such entities, are resolved. A whole lot of due diligence processes are involved. On all of the bidders will send in their consultant, accountant, to carry out both financial due diligence and tax due diligence, and even accounting due diligence. Okay, you want to be able to be sure that what you are taking over is what it is. Of recent, we know that a company was acquired, and at few months down the line, it was discovered that they virtually have taken over a whole nothing. And that was because proper due diligence was not carried out. So for such public enterprises, you can be seeing assets, you can be seeing offices all over the place. Those are the ones you have to pay proper attention to, ensure that those values are something that you can hold on to. Because the customers may not be on ground, because those are the things that are also supposed to be taken into consideration when you are determining how much to pay for such public enterprises. Are they still devoted to the companies? You talk about NITED. When we have corporate entities that are well managed and run, that are on ground, okay? So you need to be able to do full due diligence on such entities. And these are the things accountants and lawyers are going to be involved in. You have the legal due diligence. How many cases do they have in court? What is the, you need to look at what is the implication, what is the cost implication of those cases if they are ruled against them or in their favor. All of those are things that are involved when you are evaluating a company, particularly public enterprises that have been run down without proper focus on corporate corporate governance, which are prevalent in corporate entities. Most of those public enterprises, the corporate governance is near to nothing. And so we have a manager who reports to nobody, more or less, and they just get carried away as if this is also like another Ministry of Works or other MDAs that has no control. Okay, so those are things that you need to carry out properly to ensure that whatever you are putting your money on, there is still some things to hold on to in those enterprises.
Thank you very much, Mr. Folonso. And just on that point, of course, at the point of going into liquidation, insolvency practitioners then come to play, right? So in terms of the appointment, how do you think that process is in terms of the suitability of the insolvency practitioner for a particular public enterprise? What are the things to look out for? What are the things that the government is looking out for in appointing a suitable insolvency practitioner for that organization?
Okay, so background knowledge is also very important, even though as an insolvency practitioner, there is no enterprise you can definitely not take over and liquidate, or if there is a need for turnaround that you can not turn around. All you need is to get in expertise, even for the ongoing turnaround of some of the airlines, the administrators, you know, are not experts in navigational or airline activities. So, but of course, there is high level of diligence that is required of a professional or an insolvency practitioner of that level to be able to carry out such work. I remember a bank recently appointed a lawyer to take over, do I call it a cemetery or something like that? And of course, it's not like the lawyer has experience around managing such a cemetery, but it's something that you only need to put in the cap of all that you have learned as an insolvency practitioner, as a lawyer, or as an accountant, okay? And of course, for public enterprises, you know, experience is very key. Experience in dealing with different stakeholders, particularly the creditors who are likely to, you know, attack the company for their own, to be able to recover as much as possible. You know, they are not likely to, you know, you said it's guided, it's mostly going to be guided liquidation, okay, and then transition to whoever is taking them over. So you must be able to manage the interests of everybody that is concerned as an insolvency practitioner. And that is why the integrity of such persons, you know, and the experience are very significant in determining who to appoint. There must be serious maturity to be able to deal with government on one side, deal with the corporate and the creditors who have interest in those entities on the second, and then whoever the bidders who want to take over those entities. The person must have very wide experience and must be ready to use experts where they are required. And that is very important. I noticed that some of our colleagues, particularly in the legal side, always, maybe for corporate entities, want to go it alone. It is always important you bring in experts as at when necessary, so that you will be able to manage such engagements.
Thank you very much, Mr. Folonso. So at this point, I would like to go back to Mr. Agoro. We're still going to come back to some other financial / money matters or accounting matters, but I'm going to go back to Mr. Agoro now. Now, in the course of dealing with insolvency or liquidating public enterprises, are there issues, jurisprudential issues? Have you come across jurisprudential issues that you'd like to talk to us about or enlighten us about?
Yes, we have quite a few. The first challenge we usually get is the court forum. You know, the primary duty of a liquidator is to collect, which we call realize the assets of the company and distribute them to those entitled, which is usually the creditors. Now, in that, carrying out that function is basically recovering monies owed to the distressed or liquidated company. Ordinarily, those issues are dealt with by state high courts, ordinarily. But once the order has been made and a liquidator appointed and the court is on and the company is under liquidation, the ramification, as one judge called it, he said the dynamism and the genetic DNA of that company has changed substantially. So it is no longer the company which they contracted with previously. It is a new beast that they're dealing with at the moment. And the only court that has jurisdiction once an order has been made is the Federal High Court. So we had a lot of preliminary objections on that point. And were
these preliminary objections at the State High Court?
Yes, at the State High Courts. We didn't go to the State High Court. We went to we remained at the Federal High Court. You remember the winding up order was made at the Federal High Court. So naturally, we stayed there as the liquidating court to recover monies outstanding. But what our colleagues were doing was that they wanted to drag us to the State High Court and start a finish. And we're just using even without being a lawyer, we're already in a court of competent jurisdiction. So why would I leave here and go on a voyage of discovery in another court? So we have high court decisions on that, which is clear that this is a court that has jurisdiction. The liquidator is not just recovering money. What he's doing is he's realizing the assets of the company in line with CAMA. So that brings in section, I can't remember the section of the Constitution, and then it brings in the Federal High Court. So luckily, none of them went, well, not luckily, there's been no appellate decision on that point, but there are few high court decisions of reference, which I think one of my slides, I can't remember, slide 8, should have that.
Do you want to share it actually? I'll probably just talk us through it.
Okay, I thought the slides were with your IT.
Mr. Goro, the IT normally gives preference to the speaker, but if you want them to share it all.
Okay, can they? Yes. Okay, let me see if I can pull it out.
I can actually just talk us through that thing.
Okay. What do you say?
If you're able to share it from your screen, you can pin it and then you can talk us through that thing. If you're able to.
Okay. That should be slide. Yes. Let me see what I can share. I think I'll need your IT's help. It's slide 8 on my slide, not to take too much time.
Okay, no problem. Okay, I mean, if you have it, you can just keep speaking about it, depending when they're able to share.
No, so I've spoken about it. So basically, one of the issues we had was the jurisdictional issue in respect of forum. Then another interesting jurisprudential issues that we had was to do with what is the position of employees on the making of a winding up order. The Company and Allied Matters Act was silent on employees, but the old section 4229, which is I think is now 571, only addressed the issues of directors, and it says directors' powers cease. But what we had to go to court. In fact, we argued the case all the way to the Supreme Court, where it has now been settled that upon the making of a winding up order, all employees are ipso facto dismissed. And as a consequence, they do not even need termination letters because the advertisement that is made, slide 8, please. The advertisement that was made before the wind-up order is deemed as adequate notice to them. So that was, yes, so that was quite a good one. And we're happy to say that the judicial landscape in that area has now been settled. Another very salient point that came up or that we experienced was how can we recover these monies without filing a writ or starting a fresh, instituting a fresh action? And during the NITEL, one of the MTEL recoveries that we did, we brought a summary judgment application within the petition. And our colleagues argue that no such thing is permissible, that the competence of that application was being questioned. And luckily, we have a case now that is reported from the Court of Appeal that said, yes, in fact, it is even more expedient to recover monies through the petition in itself than going away to commence a fresh transaction, a fresh writ, institute a fresh writ. So what that has done, it has made it much quicker to recover monies that is owed to the company within the petition itself without going outside and filing fresh action. And the language which was used in CAMA was prima facie entitled. Any monies that is outside that the company is prima facie entitled, then the liquidator is able to, in fact, basically snatch it and give it to the creditors. So we have a few summary judgments applications on that, based on that authority. It's called Otumba Shembore versus UBA. And another interesting point that came from that is that even after getting the judgments and having the judgment in your pocket, the appellate process will now start again, where you are still waiting to recover money for these creditors, some of which are even old people who have worked for the company 20 years ago, and all they need is just something to retire with. So my suggestion is, I think issues to do with liquidation, recovery should end at the Court of Appeal, so that creditors who are owed these monies can receive it, enjoy it, and not wait till they get to the Supreme Court, where we don't even know where you get a date for hearing. So these are the one or two things.
Mr. Agori, you make an interesting point. So would you be advocating for it to end at the Court of Appeal, or probably to create a rule whereby we have a certain period within which such matters need to be disposed with? Such that, so even if the matter goes to the Supreme Court, like you have in election matters, for example, even if the matter goes to the Supreme Court, you know that there's a certain number of days where these matters have to be dispensed with.
Well, that's another very good idea. But my general thought process is that there's no point overburdening the Supreme Court over an issue that is almost like an admission. Most of these matters, it is usually on summary judgment applications. We don't even go through trial. It is clear, it is black and white. Like one of the particular case, a certain amount of money just disappeared. You know, when a company is distressed, like a public enterprise, everybody does what they want, including its bankers, the managers. So this particular case, a certain amount of money, quite a lot in euros, disappeared from the accounts. And all we did was provide the statement of accounts where the money was sitting there, and we provided another statement of accounts where the money was no longer there. So it stands to reasoning that we did not withdraw that funds. So who withdrew the funds? So such matter need not even go into further deliberation. The money was there and is no longer there. So provide it. So under that summary judgment application, such a fund was easy for us to recover such a fund. Now we have the money as a judgment debt. We can't get the cash itself because we've gone to the Court of Appeal, which we ought not to. So my point is, I don't think we should overburden the Supreme Court with such simple issues, but let such matters end so that the parts, because the High Court judge may get it wrong. So that another panel can have a second look at it, and then thereafter let the matter end. But luckily, actually, a clause which we don't usually use is even inside the Public Enterprise Privatization Act. There's a tribunal. There's a tribunal where such matters are supposed to end, in fact, summarily. So we should also make use of the Public Enterprise Tribunal, which I think is something that will be arbitration panel, Public Enterprise Arbitration Panel. That's it. That I think it should be very useful going forward. So that's my thought process.
Great. Thank you very much, Mr. Agoro. Can I just say that if you have any questions, please drop them in the Q&A box. I've seen some questions in the Q&A box, and they're actually asking about the slides. Yes, the slides will be shared with all the attendees at the end of the session. But please, if you have any questions in relation to what has been said so far, please drop your questions in the Q&A box. So, Mr. Folorunsho, I'm going to come to you now. So, like, you heard when Mr. Agoro said that the court held that once there's a notice of winding up, that it's deemed as notice to the employees of that organization, they're deemed dismissed. So, in your experience, what's the obligation of the insolvency practitioner, especially to the staff members of an organization?
Okay, thank you very much. Of course, you know that that obligation of the practitioner will depend on the nature of the exercise, whether it's a liquidation, like you just mentioned, a receivership, and a CVA, and as an administrator. So all of those determines the nature of obligation applicable to the practitioner when it comes to employees. And for high-class organization where restructuring is involved, and probably where you want employees retained, or where employees have an agreement in place, compensation of the CEO and the exit pay are very significant things that the receiver manager, the administrator or nominee, as the case may be, or even the liquidator must take into consideration. I know that we used to insist that our obligation is limited to only maybe 12 months outstanding salary, okay? And of course, even the tax implication of that also means that you will have to pay to the state the personal income tax on the 12-month salary. Of course, we know that immediately a publication is made as to the appointment of a liquidator or as a receiver, the tax authority always, come up with their own claims. So, like I said, it depends on which appointment or which exercise, which assignment you are carrying out that determines what obligation as an insolvency practitioner, what obligation you have to deal with when it comes to staff remuneration, whether outstanding. Some of them, in the past, we have had experience where companies have a gratuity obligation to their employees. And the fact that you are appointed to take over the running of the entity cannot extinguish that obligation. It is just that you also have to bring those obligations into the distribution list, or maybe in terms of priority. Look at where it falls within the priority list of payments that you have to make. So it depends on those type of the nature of the assignment.
Great, thank you, sir. And then you mentioned something about paying the obligations to pay personal income tax in relation to the employees. Now, just even broadly speaking, or on a broader perspective, in relation to those companies, the public enterprise that is being wound up, can you please just walk us through the tax implications generally, for the company itself, and for the public enterprise that is being wound up, and even for the bidder or the preferred bidder now, who is ultimately going to take over those assets? Can you please just walk us through the tax implications and burdens on each entity?
Okay, so for public enterprises, it depends on the specific type of enterprise again, because some of them are strictly public enterprise, which means they are non-for-profit per se. If you take the NITEL as at that time, or any of those public enterprises, some of them even claim that they have no obligation to pay tax because they were initially 100% taken over by BP and all that. So they claim that they don't have tax obligation. Tax obligation I mean by corporate, I mean by their company income tax liability or education tax liability. But if it is strictly public interest, but it's a limited liability company or a corporate entity, the obligation for tax will still be there, which means taxation forms part of the priority payment that an insolvency practitioner must always take into consideration. Otherwise, the practitioner will be held liable for the taxes of those entities. And therefore, if you are interested in those public enterprises, you will also want to ascertain carry out a tax due diligence to be able to ascertain the tax obligation that are already on ground. Even if the entity is not a taxable entity, that is, the income of such entities being public in nature are not subjected to tax, they have tax obligation as collecting agent for government. Recently, the federal government issued a regulation on source deduction, which we call withholding tax. Okay, most of those enterprises have withholding tax obligation on their vendors, contractors, and some of them run into billions, which must be properly taken into consideration as part of the priority payment that has to be taken care of by the practitioner. Okay, apart from that, the payee tax and other deductions that the company will have been expected to remit during their active period will also come to the fore, because those deductions, because it's a sole deduction, the issue of statute bar sometimes don't apply, because you are just been appointed as an agent to collect. Not that we are not discussing your own tax obligation as an entity, but we are discussing your agency responsibility and obligation to government to help withhold tax from payment. And where you have failed to do that, you know, penalty at 10%, interest at the ruling commercial rate plus, you know, which is currently MPR plus 4, will come to play. And so they can be very significant when it comes to insolvency. And our members there are things that we always take seriously, particularly when I was with my former firm. We always take tax obligation and we ensure that all the tax issues are dealt with properly. Otherwise, sometimes you thought that you have finished an insolvency assignment and you just receive letter from the tax authority, okay, that, oh, as an insolvency practitioner, you have stepped into the shoes of the company, and therefore the obligation is on you. So these are things that one takes serious attention to, and then you must carry out proper due diligence to ascertain the obligation and look at the law to the extent to which you are required to pay liability. Those are things you must take into account. Thank you very much.
Thank you so much, Mr. Folorenshaw. That's really insightful and interesting. So no matter how much of an ailing company it is, it still has to meet its tax obligations one way or the other.
Of course.
Okay, so I have a question here in the Q&A box. Please drop your questions in the Q&A box. There's a question that says, well, even though we're talking about public enterprises, but it's asking a question on private limited businesses, but I think we should just take it. It says, in the case of private limited businesses, where the receiver is suspected to have defrauded the business by selling assets at less than value for his interest. What are the options for the shareholders? Mr. Folonsh, I think I want you to take that. Basically,
Okay.
if the receiver, yes, okay.
Okay, so of course it is unethical for a receiver manager to find a way around, realizing the asset of the debtor and now being the person that either buy it or sell it unprofessional, So that is why there is always a need for proper valuation to be carried out. Okay, even if you talk about for sale value still have a value, and that must be taken into consideration when you are selling such assets at distress point. Of course, if you are appointed as a receiver, it means that you are to take over the charge assets of the company and realize it, to offset the obligation to the secured creditor. But if you find yourself, being unprofessional, being unethical, whatever, it is not expected of an insolvency practitioner to do that. And whatever applies, okay, the question is, what is the
what are the options for the shareholders?
Option for the shareholders. Okay, for a company that is at distress like that, and to the extent that a receiver manager has been appointed, it means that the secured creditors have taken precedence. Okay, and if they align with the receiver, or if they are aligned with all the actions that the receiver has taken, okay, there's really little that the shareholders can do. Okay, of course, is to find out the outstanding indebtedness of the company. Okay, they have managers whose position have now been taken over, and the receiver has now taken priority. So it's between the debtor, the secured, the bank, and the owners of the company. The shareholders are far away from this. It is only when all of those obligations have been settled that we'll start talking about the distribution to shareholders. That is very remote in our system, but it does happen. NDIC have done so many of that and paid some dividend to shareholders. I don't know whether Mr. Abgoro wants to say something on that as well.
Yes, it's an interesting question. As you rightly said, the shareholders are at the bottom of the pecking order because basically it's the risk they took, and general creditors, secure creditors first, then shareholders come at the bottom. But if it is found that a receiver has done something unprofessional, yes, my immediate task is, first of all, find out whether he's a member of ICANN or is a lawyer, and report the matter to the disciplinary committee of those bodies. I think that would, because that is going straight to the heart of the issue. And if he's investigated and found that he did something untoward, then it can be taken up by his professional body. That's the shortcut I would take if I was involved in such a
And of course, if criminal act can be established, the law enforcement agents can be called upon.
I'm prosecuted. Yeah.
I know that there are several insolvency assignments that have been engaged in,
law enforcement,
and the owners will always report, and they have this way of. I've been taken to the IG's office in Abuja. As long as you know what you are doing is straightforward, you have nothing to fear.
Great. Thank you, sir. I'll move on to the next question. This person says, as rightly pointed out by Mr. Agoro, writing his slides, that a company in liquidation is protected from lawsuits in order to avoid delay with the liquidation process, except with the leave of the Federal High Court. Does the same rule apply to companies under receivership? If not, is there any pre-action procedure one ought to comply with before bringing an action against a company under receivership? Mr. Agoro, I believe that question is for you.
Yes. As I said, a company under compulsory winding up is insulated from external attacks on the company, such as suits without leave. But unfortunately, receivership doesn't enjoy that protection. That protection is strictly for a company. Yes, not even just ordinary liquidation, compulsory liquidation. Compulsory, which is liquidation by the court. So if it's under receivership, all those suits will still be flying around. I'm not aware of any issue of obtaining leave prior to suing such companies. They just have to face the general process, because the whole idea of receivership is it is just badly managed, and let's bring in somebody else to do the job. So a company receivership is still a going concern. Unlike a company under liquidation, which everything stops and it cannot become a going concern if the liquidator decides that it could be, and he still has to go back to court and make it a going concern. So there is no protection, immediate insulation against suits in the receivership.
Okay, but I can add to that, Tosin, which is, if a company is in the receivership, is only representing the bank, or maybe the secured creditor,
the creditors,
the type of appointment, or depending on the type of security, whether it is one that we have been appointed as a receiver or as a receiver manager with fixed and floating debenture and all that. So the step that usually one takes is to obtain a preemptive action. Most times we obtain an order, stopping other unsecured creditors, because they believe that they are at the end of the sharing table, and therefore, if they allow the secured creditor to realize the asset, they probably will get nothing. I most times deal with people coming up with a court order to FIFE asset that of a company that is already in receivership, and that will jeopardize, the assignment. So what you do is to obtain a preemptive order against every other person, okay? So that if they have any claim, they should file their claim like any other unsecured creditor. And all you need to do is to ensure you also arrange a meeting with those unsecured creditors to assure them, of the program of action, what you intend to do, if it is one you are running, how you want to be. Some of them, most times, are mostly suppliers of raw materials or buyers that have deposited. I remember running one palm kernel processing plant that also have equipment for fractionating palm oil. We're getting credit from unsecured creditors supplying their palm kernel. We're also having deposits from the Danica ladies that want to take whatever you have. They are purely unsecured, and they know that if the receivership is concluded in that manner, only the secured creditors will be taken care of. The fund is not going to be enough. So you must be able to manage them, get that preemptive order, also take them into consideration, ensure that as you are paying, if it is a receivership management that we are running, as you are paying the secured creditors, you are also paying the unsecured, particularly for the ones that are your obligation during your appointment. The ones before your appointment, you can park and assure them that as long as you continue to do business with me, I will pay the current obligation. Those other obligations before now, because those ones are your indebtedness, those other ones are part of the unsecured, which may be covered when the receivership is concluded.
Thank you, sir. Mr. Folonsha, this question is also for you. Okay. It says, can a reporting auditor be appointed as a receiver to their client?
The answer is no. There will be conflict of interest, and it is advised that you decline such appointment. Okay, I think that's just straightforward.
Thank you. And it says, in the case of all outstanding, or in a case where all outstanding obligations have been met and there's an excess to be returned to the shareholders, what happens? You return the excess to the shareholders. Does that happen?
It does happen, because at the end of the day, there are some times that the receivership is about a specific sum. And as soon as I remember taking over the asset of a company that was imported at the port, even before they are taken to the factory. And we sold it right there, recovered the money, and then what we recovered was a little bit more than what the company was owing. So, of course, we'll return the balance, take your fees, return the balance to the creditors, to the debtor, and they continue to run the business. I mean, it's possible, right?
100%.
In liquidation, we still have payment to shareholders if there is any.
If there is excess.
Yes, I'm sure Mr. Guru.
Thank you very much. Okay, I think this is the last question, and I'm throwing it open to either of you. It says, what distinguishes the winding up by whatever means from other business rescue arrangements such as administration and CVA?
What's CVA?
I believe. Hello?
I said CVA.
Voluntary
arrangement.
Voluntary arrangement.
Oh, okay.
Yes, company voluntary arrangement. You want to go first, sir?
Yes. Well, for me, there's a lot of difference. A lot. As I said earlier, liquidation winding up has its own special rules, but the most important thing, it is mainly guided by the courts. I'm using the word guided now loosely. It is run by the court itself. And what that means is that a lot of the powers derived by the liquidator is given to it by CAMA and the courts. Now, with other forms of business recovery, rescue, it depends on which one you want to go in. As Mr. Folonsha said, if it's receivership, it's a different rule because receivership is done primarily by a creditor whom demands a particular amount of money. And once that money is settled, that ends the receivership job in that particular aspect. Then administration also involves what it is that the administrator is looking for. Is invariably the same thing: insufficient funds, somebody's owed money somewhere. But the rules that govern each particular process is slightly different. As I said earlier, compulsory is different to voluntary. Receivership has its own rules and administration has its own rules. So you need to just check what the rules say one by one, and then decide which one is best suited for the particular company.
Okay, so if I can add to that, a CVA allows a company to reach an agreement with its creditors to repay its debt over a period of time. The arrangement is proposed by the directors, and if approved, the creditors is supervised by an insolvency practitioner. That is for a CVA. An administration, the process aims to rescue the company as a going concern, that is to achieve a better result for the company's creditors than will have been achieved through liquidation. Okay, the board of the company is suspended at that point, and an administrator is appointed to manage the company's affairs, business, and assets. And that differs from the receivership process, which involves appointment of either as a receiver or as a receiver manager to control the company's asset and or to receive proceeds from the disposal of such asset. And such proceeds are channeled toward paying, the creditor's obligation. And all of those are different from liquidation or winding up, which is to bring the company and business to an end, which can end up even with removal of the company's name from the register. Okay, I think that's those are the specific distinction that time will permit. Otherwise, we can go into details
of each one.
Our time is actually fast spent, and I was honestly going to close the questions, but there's this question. In fact, we can't take all the questions, but there's a question that talks about the future, and I think it's something that we should actually just speak about. It says, what role do you see digital transformation playing in the future of insolvency and restructuring processes for public enterprises?
Come again.
What role do you see digital transformation play in the future of the liquidation and insolvency of public enterprises? So basically, does digital transformation have a role to play in the near future?
definitely, you know, receivership is about obtaining the information of a company, you know, carrying out due diligence on those companies, ascertaining the assets and liabilities, determining what assets the company has, and then dealing with bidders who are interested. All of this can be done electronically. And I think that is that's the future of everything. And everyone must begin to understand or address how this can be, you know, can be applied in practice. You know, and even presently, what we do is we have a data dump where you can electronically, you know, access those data to carry out your due diligence. You prepare your own proposition, drop the information in the data dump, and all of this can be done electronically. So it is definitely something that everyone must begin to, you know, be interested in and see how, you know, it can fast track and ensure proper process of either liquidation, as the case may be, or even turnaround management or rescue.
Thank you very much, Mr. Yeah, I see that you have your hand up, although we've more or less run out of time.
You have refused to give me the opportunity to ask these experts.
Sorry, I had questions in the Q&A, loads of questions.
It's fine. I wouldn't take time, but these are for Mr. Agoro, and thank you once again for both of you for a very incisive and insightful presentation. But I just wanted to double down a bit on the jurisprudential issues that you raised, Mr. Agoro, which is quite practical and the way it should be, which is that many small issues of judgment are done within the context of the insolvency proceeding itself, because it is a collective proceedings and it does not allow for different other judicial proceedings to be ongoing. But the point here is that when you get the judgment, so how do you now practically deal with the issue of enforcement on the one hand, and then where do you place the issue of use of in-rem attachment, solutions and forfeiture solutions, so that you are able to be able to actually take control of assets that may have been cannibalized, particularly for public enterprises. Thank you.
Yes, it's a difficult question, as I expect from Okori. What the challenge we've actually had is not, first of all, the biggest hurdle, the big hurdle, which we're happy to have crossed, is this summary judgment applications. Now, we have quite a lot of judgments in our pockets, but enforcing those judgments have been stalled by the legal process. Not so much because the judgments are watery, but because we have to go through that process. When you have a judgment debtor who has appealed what I call a straightforward, clear judgment that this speaks for itself, and decides to go to the appellate courts, and after that decides to go to the Supreme Court, it makes, in fact, it doesn't even, we won't be able to end the liquidation process. So those are the challenges which I spoke to, and I said, my suggestion is these cases, especially when it comes to summary judgment applications, should end at the Court of Appeal. And also we should look into the arbitration panel, the privatization and commercialization arbitration panel. Yes, look into those two. And those are the ways we'll be able to now recover those funds in hand, not just as a judgment creditor, have those funds in hand and then be able to distribute them. So the question is very good, but we don't have an answer to it today until the...
So would in-rem attachment then and feature orders help in that area?
Say that again.
So would in-rem attachment and forfeiture orders ultimately help in that area? Because you know those ones go directly to the asset.
They do, but they're still appealable.
Fair enough. Fair enough.
That's the challenge. They're still appealable. So you have all these beautiful judgments and processes which you have in hand, but you can't convert it to money. And the worst part is, especially when it's a public enterprise, these funds are there for a long time. So you have a 2010 29 judgments in your hands and you can't convert it to practicability. So that's been a very big challenge. Imagine the value of the money then compared to it now. So we have to find a way to end this recovery process in the shortest possible time. And my suggestion is, as I've said in my slide, at the cut of a period.
Thank you very much.
Thank you.
You're muted, Tosin. You're enjoying yourself alone. Somehow you're still muted. Okay, fine. You're
My
here.
apologies. I'm saying that we've actually really run out of time. I see more questions dropping, but honestly, we've run out of time. But I've actually had a very enjoyable afternoon. We've learned both the practical and the book knowledge on insolvency of public enterprises, and so we've even had to delve into insolvency of regular companies as well. Honestly, I think it's been a very enriching session, and I'd like to say a very big thank you to our speakers, Mr. Folonsho, Mr. Albert Folonsho and Mr. Adetokunbo Aguru. I'd like to say a very big thank you to you on behalf of the chairperson of the SBL, the NBA section on business law. Thank you very much. We actually have our chair here. I don't know if he wants to say something. Dr. Adeoye Adepoju is on the call. I don't know if you would like to say something just before we close, if he's able to speak. Sorry to put you on the spot, Doctor. Okay, well, he's not unmuted. So I'd like to say a very big thank you to you on behalf of the Nigerian Bar Association section of business law, and on behalf of the Restructuring and Insolvency Committee. I'd like to say a very big thank you to you. The slides will be available. The slides have been sent to the Secretariat and they will be available. I'm sure they will be shared with all the participants because there are lots of questions about the slides. So the slides will be made available to everyone on this call. Thank you very much for coming. Thank you.
Thank you.
Have a good afternoon.
Thank you. Thank you, everybody.
Thank you, Tosin. Yeah.
Thanks.
Bye, everyone. Thank you so much, Tosin. Bye.